Okay, good afternoon, and thank you for joining our session this afternoon. We have got Ross Milvenan from Digby Brown. Ross is a solicitor with a specialism in law, and he works in the head office in Glasgow in the employment department. And today he's going to speak to us about COVID-19, your employment rights. What we'll do, if you have a question, could you pop it in the chat? And at the end, there's an opportunity to raise your hand and ask a question in person. So I'll hand over to you now, Ross. Thank you.
Thank you very much. Thank you very much, Susan, and thanks to you all for coming along this afternoon. I'm going to go through a PowerPoint and explain what we're going to talk about. If anyone needs to come in and out the room and going into different rooms to see different some other topics on, then please by all means feel free to do so. So what we'll do, I'll just put the slides on the screen. Just a second. So what I want to talk about here is some employment law rights that may have come out of the coronavirus, the whole COVID-19 pandemic. It's been busying us all for the last 18 months or so. So really what I'm thinking about here is the employment law angle on different considerations. With this briefing is really to provide an outline of the rights that you might have in a workplace setting that have come out from COVID-19. All be aware of the impact it's had on all different life, and now restrictions are starting to be placed and people are going out and starting to interplay with the complexities of employment law and some practical issues that arise from that as well. So really, it's really just to create an awareness of the type of things that you may well come across. So the content, what we're going to run through this afternoon then, is going to have a look at furlough in the furlough scheme. Issues about returning to work as well, and how that vaccination as well, about some legal can and can't do, or employers can and can't do. Vaccination. Touch on self-isolation as well, and how that connects with the employment laws and what your rights are to pay there. And also a bit of a practical advice on how to deal with any issues that might come out in the workplace should that arise. So that's going to be a bit of a whistle-stop tour to what we're going to cover for the next wee while. First thing I wanted to have a look at then is furlough. In the abbreviation there, it's the coronavirus scheme. This is the scheme that the government came up with last year around the time we were all being and stuck in our houses for a wee while. Latest figures that we have, or the government have produced in July this year, is that throughout the period, the 18 months or so that furlough has been in operation, it's been 11.6 million employee jobs furloughed. So huge, fairly huge numbers. The idea behind the furlough scheme was to try and keep people in work, trying to retain people in employment. So effectively, it was an alternative to redundancy for a lot of employers recently. Government will obviously keen on people working, keeping them in a salary, keeping employers going, keeping the businesses actually running, and of course people having some ability to spend. The alternative being businesses closing, people their ability to earn being severely restricted. So that was the idea behind it. When the scheme was rolled out, it first came, the idea came, it was announced, and that's fine in the theory behind it. There then became a bit of a complexity, certainly for employment lawyers and for employers, as to how to actually implement the scheme. Certainly the government were saying, right, we will pay initially up to 80% of wages, try to keep people in their jobs while they're not able to work, and safeguard that employment for the future. So I had employment lawyers and human resources professionals and employees running around, firstly looking at the dictionary definition of furlough to see what this actually meant, and then really looking at the practical effects, how this is actually going to work. So wages were being paid, and the rules have changed over the period of time. For a long time, employees' wages were being paid 80% of their full wage, subject to a limit, which was £2,500. And that's how, in effect, how the scheme operated. Employer then had discretion; they could pay the extra 20% to make up to full wages if they chose to do so. The government would certainly pick up 80% tab on that one. So there were certain conditions applying to it. See, that's changed over the piece. It's been extended at least a couple of occasions because the coronavirus pandemic was going on, and people simply weren't able to get back to work. So the rules changed, and the level of payments changed, and what work you were allowed to do changed, and the rules were quite detailed. What has happened now, though, is at the end of last week, is the scheme has ended. It's literally come to an end as of 30th of September. So that's now gone. So the situation for anyone who's been left in furlough in a row, there are still a number of people, mainly in the arts and entertainment industry, according to the government figures, that's gone. So the government payments have now stopped. So really there's a choice for employers. Can they afford to keep people and keep their businesses going, or is a redundancy an alternative? I have seen even just today in the news, it was reported that there hasn't been huge numbers of redundancies or planned redundancies. That's come from the government figures, so you get reporting, and there's reporting on how many employees are likely to be made redundant. It's a process there, so they're not expecting huge numbers of redundancies, which is hopefully some pleasing news. But the cost of it, though, see there, it's been huge, astronomical, really. And almost £66 billion has been spent across the period. So it's been a huge scheme. So hopefully it's safeguarded a lot of jobs over the piece, and it will be onto the future as we'll start to get back to work. And that's the next thing I wanted to have a look at: returning to the office and quite how that is going to happen. This photograph here was something similar to what I saw this week. Returning to the office myself at Glasgow Central Station as commuters were getting off packed trains. Thankfully, not quite as bad as wearing a full hazard suit. But returning to the office does bring up some issues to safe not to do so. So up until now, and still now, guidance is to work from home. Even if you're a solicitor, not so easy if you work in and go to. But you can work from home. The advice remains to do that. What has happened, and no doubt I've heard about this in the news and in other places, flexible working has popped up. This is certainly reared its head. And the thinking there is people who have been working at home, just getting on with their work and able to do that. In some cases, increasing their productivity, by not having to commute and come into work, and it's a cost saving to employers as well, not having employees in the office. Flexible working has cropped up. So the idea is now moving towards the future, changing people's terms and conditions to give them more flexibility as to where they should actually be. Contracts for employment would ordinarily have a clause in there that says where you should be working. There's normally some mobility in there. We can send you certain places if we need to do that. Now employers are seeing the benefits of working at home, but also the benefits of having people in the office. We can work together, share ideas, communicate a bit better. So this hybrid model of working is cropped up. That's something that we'll be doing in Digby Brown. We'll start to get back into the office now. We've been for a couple of days, or depending on particular arrangements, and then able to work from home a bit more flexibly for the rest of the time. So certainly a big move towards that in jobs with that lend itself to working at home. So that certainly seems to be the future for some jobs. There is, however, a requirement to keep the workplace safe. We just don't want to have employees all coming back into the office at one time, all getting on trains and lifts together, thinking about an office environment, and then spreading coronavirus and all that getting out of control again. So the advice that's coming, and a lot of this is coming from ACAS, so the government organisation that's set up to give employment law advice and guidance to employers and to employees. So the best place we can get for any rules is coming from the ACAS guidance. So a lot of this isn't law. It's really just the government saying here's the best practice that should be followed. ACAS are producing loads of guidance on this. I have at the end of the slide just a reference. If you need to have a look at any of that, you can go and see what it is that they're recommending. But it needs to be a safe way of getting people back to work. So in the office, whether that's taking temperature, making sure people sanitize, keep a nice distance, all of these things should be happening. So employers get a duty to look after the welfare of employees, and that's exactly what they should be doing here. The hybrid model of working probably helps with that. For example, if we're working 2 days per week, allows there's less people in the office, means it can be spaced out a wee bit more, and it probably helps with keeping people safe, following all the guidance. So that's generally how returning to the office should be managed. All of what ACAS are saying, and this is a theme that runs through all their guidance, is they're asking employers to be flexible and to be reasonable with people, talk to them about it if they have concerns. So it's very much involves a lot of cooperation on both sides. Where this starts to impact on the employment laws, particularly in relation to potential discrimination and disability discrimination claims, it's where the employer has a duty to make reasonable adjustments for people who have what the law would call disability. So there's a certain definition of what would be a disability. And the legal wording of that is someone who has a physical or a mental condition, which is a long-term condition, and has what the law terms are substantial adverse impacts on their day-to-day activities. And that would be someone who has a condition that meets that would then enjoy the extra protection that the law provides. And meeting that definition, we'd only ever get a decision on that from an employment tribunal. If medical advice meet that definition, then that puts a duty on the employer to make reasonable adjustments. So reasonable adjustments can be anything, whether it's adjusting hours, working practices, whether it's physical adjustments to a workplace, whatever it happens to be, to try and alleviate the effect of the medical condition. So employers have a duty then to consider these things. They don't have to do it, but they have a duty to consider that and implement it where it's practical to do that. So where people are returning to work or employers are asking them to return to work, those who have disabilities then they can consider making requests for reasonable adjustments. And if that's following medical advice to work at home for a longer period, I think you hear about the shielding periods. There was advice for people to shield, because of the risk of coronavirus. That's obviously been reduced now, but there will still be some medical conditions where people have a genuine concern about going back to the office. So if they have a condition that meets the definition, they can ask for that. They can ask for reasonable adjustments. So that's quite an important right to be aware of. Other issues that might have returning to work, and certainly this is something that last week, where employers are asking people to. Normally, this will relate to reporting. There hasn't been lots of redundancies as a result of the furlough scheme coming to an end. Certainly, I know I've spoken to one person last week. The employer has said, I want you to take a pay cut. They've been working, I think it's maybe not went into details, I think it's maybe 60% of the time they've been paid wages in accordance with that. Now they're due to come back to work and the furlough scheme is coming to an end. They've been asked to change the terms and conditions and say, right, well, we can't afford to pay you. That's what the employers saying in this particular case, can't afford to pay you your full wage, but we'll change your terms and conditions. You work less hours to 25 hours rather than full time, and be paid for that in proportion. So maybe not a great or attractive option for the employee in the first instance, but leaves them with a decision as to what they can do. What the law says in this is that employers aren't allowed to change the main terms and conditions of a contract. They just can't say, right, you're going to work 10 hours less this week, and you're going to be paid 60% of your salary, or whatever it happens to be. Simply can't do it. They can't change the main terms of the contract. They can be changed though if the employee consents to that. So if they say, right, well, the alternative to this, if I don't accept a pay cut or whatever else that they've been asked to accept, if I don't accept it, then I won't have a job. And people have the choice. They can say, right, well, I will consent to it. So, but we certainly don't have to. So a decision to be made there if that's something the employer is proposing. So there's certainly some rights there, maybe decisions to be made. One other point I wanted to touch on is long COVID. And there's been lots of discussion about this in the media and elsewhere, and TV screens are full of experts telling us what long COVID might be or might not be. What this throws up in the employment law sphere is whether long COVID could be a disability, whether the symptoms there would meet this definition, long-term effect, having a substantial adverse effect on your day-to-day activities. Some of the conditions that have been reported, some of the effects of long COVID, really quite serious. It's really knocked a lot of people for six. Whether that meets the Equality Act definition for disability, not quite sure at this moment in time. It'll take a while for cases to go through courts to consider whether that is a disability or not. If that's something that applies, or if you know someone that this might apply to, the best way to deal with this would be to report the symptoms to the employer, obviously, and say it's a disability to try and get that extra protection that the Equality Act provides. So while it might be uncertain, and we'll never know once an employment tribunal judge made a decision on it, if it's serious enough to say, right, this condition, the effect of this condition is amounting to disability, therefore reasonable adjustments and whatever else it may be that's appropriate. So a question mark over that. I expect it may take a long time before courts consider whether long COVID disability, and it might affect different people in different ways as well. But certainly that's something to be aware of if that becomes an issue. So that's about returning to office. Some other issues that may well come up on returning to work. Vaccination. Sometimes a controversial issue. Some people are very for that, and some people are against it. It's an understandable anxiety. Some people.
Sorry, everyone.
Sorry, bear with me a wee moment and see if we can sort out some problems without sound here. Let's try this. There we go. Hopefully that's helping out a wee bit. So you can let me know if not. Yeah, so vaccination, whether or not we should get that. Really, I think the question is whether it's a requirement for work or not. At the moment, it's not a requirement for work. There are certain occupations in England where they've said you need to vaccination to the care industry. So that will be an occupational requirement for people there, and that's what the government have decided. Other than that, no. What has come across, and this is guidance rather than the law for anyone else that's not required to get it in the care sector, is that employers should be encouraging people to get the vaccination. Government advice is to get it. Employers have been asked to encourage, but not force, not require people to get the vaccination. So that's certainly where that particular situation is at this moment in time. There will, of course, be exemptions. There will be people with certain medical conditions who are exempt from having the vaccine. people who are pregnant as well would be exempt. So employers certainly shouldn't be forcing people to do that. Again, that's just something to have an awareness of. To touch on as well, certain rights or not that may happen relevant where people have to self message and say, right, you've been in and therefore that then impacts on work. It's a big concern for a lot of people, particularly where you have a job where you actually have to go out and be at your employer's workplace or out and about. As much you can do here really is follow the medical advice and what the medics are actually saying. You have to follow the self-isolation advice. What this would mean in practice then for individuals going to work, they need to stay at home for the time that's been identified. What you should do then as an employee is check whether your employer has any policy about this. And the policies, they might have a specific policy if they're switched on the employer that's moving with the times. Lots of employers will not have that yet. What it comes down to is effectively whether the employer has a sick pay policy. So it would be the normal sick pay terms that would apply if you have to self-isolate. So some employers will have that, and they might have a contractual period of time. Some local authorities have like a certain number of weeks or months where you'd be paid full pay or a certain percentage of pay for. So it's these rules that would kick in if you have to self-isolate. So if the employer has that type of policy and they pay more than what the government provides for statutory sick pay, then that's what would happen. It would follow the normal sick pay rules and normal policy about reporting and fit notes, etc. to the employer. If the employer doesn't have a contractual policy where they pay more than statutory sick pay, then it would be down to that. So the employee's right is to receive payment at the statutory sick pay rate, and that's where we are. That's what the rules are providing for at this moment in time. There are some support payments available. I think there is a grant about £500 that's available for certain people who qualify for that, where they have to self-isolate and then can't earn. It relates to very specific rules for it. It's effectively, you have an income-related benefit, then you can apply for that. There's some detailed rules in the government website. You'll be able to have a look for in that. That's just one to flag up. Similarly for carers, so if you have to be a carer for someone and you're told to self-isolate, the same thing applies. So if you're employed, it would be your employer's policy that you would have to look at for sick pay. And again, the same rules would apply there. So that's how that works so far as being asked to self-isolate is concerned. To have a look at also is what happens when there are issues. What happens when there are issues? So if you have a problem with actually getting back to work, medical conditions, into that, or the other reasons.
Sorry to interrupt you, Ross. There, your sound's gone completely.
Is it? Okay.
Oh no, you're back. It's in and out.
Back again now.
Yeah, I can hear you now. Thank you.
Excellent. Okay, if it goes again, just if it gives a wee wave or whatever else. Yeah, so thinking about issues that might then arise if there's a problem about getting back to work, or if it's hours that are working, where you're working. And what you should do first of all is approach the employer and try and sort it out informally. So whether that's speaking with a manager, whether it's the human resources department, whoever else is the relevant point of contact, explaining what's going on and trying to sort it out in a practical way. You know, I'm caring for someone, I can't come into work, I can do my work at home, coming up with an arrangement. And the government are encouraging employers to be flexible about that. That's one way of dealing with it. Hopefully that's the aim of sorting things out, some communication there. If not, and it becomes an issue, or the employer is not being flexible about it at all, then you would have the right at to raise a grievance, a written complaint to your employer. It's a bit more of a formal process. The idea behind it would be then to say, here's the issue, get it in writing in an email or whatever the employer's policy provides for. As long as you're raising it with them, best it's in writing in some form to keep a notice of it. Get it to the employer, and then there's a duty on them there to take that on board, go and investigate it, find out what it is they can do to work to try and resolve it and try and sort out what the issue is. And that's down to the employer. That's putting the ball firmly in the employer's court, saying, here's the issue, we want to try and get this resolved, and then let's do that. So that'd be like another step if it couldn't be resolved in a straightforward way. May also be issues that arise in relation to reasonable adjustments. Again, so that would be someone who's meeting the definition of disability. So if the employer has been difficult in some way, or you simply you have medical advice that says, I must work from home because of a medical condition, or potentially because I'm caring for someone as well, then you can ask the employer to make whatever the adjustment required is, so it then doesn't put you at that disadvantage. So that's also something to bear in mind. That can be quite a powerful one where that applies, because the employer has the duty to make the adjustments. I think then about certain claims, legal claims that might then arise. I hope that these things don't happen, but it's good to have cases that have come before, well, mainly employment tribunals so far, relate in the main to discrimination. There's been some discipline. Also in relation to health and safety as well. There are certain very specific legal claims where an employee is automatically unfairly dismissed if they raise health and safety issues, if there's a serious imminent danger in some other rules, but it's very specific claims about that. What's happened with these cases so far, because they take time to go through the court system and employment tribunals, all the decisions that have been reported so far are decisions of the employment tribunal, which is fine, and some of them are found in favour of the employees and some in favour of the employers. A lot of them are very fact specific, so it really depends on the particular circumstances as to what the outcome would be. But it takes time for these cases to then go to appeal courts where it's looked at in more detail, and that's where the laws can often be formed. So it might be a while before we hear more about these things. The cases so far, this tends to be the area that they've been in. If you did have to pursue a claim for any reason, then just be aware of the time limit to do that. Employment law claims are applied fairly brutally, so it's a very short period of time. So a claim has to be lodged within 3 months, 3 months less 1 day from the date of the act of discrimination that's complained of. So if there is something along those lines, then just be aware that it's a very short time period for that, and best to take some advice. What I did want to mention as well, just before we wrap up, is some protection for carers, which may well be relevant. So if you're someone you know as a carer for someone who has a disability and meets this legal definition, there's potentially some protection there also in relation to the carer's employment. And this is the legal concept of associative discrimination. So that prevents an employee, so let's say a carer, being treated less favourably than others because they're caring for someone with a disability. Let's put too fine a point on it. So there is some protection there. So it's about being treated less favourably, which is direct discrimination. So if someone, say you're a carer, you have to work from home because you're caring for someone who has a disability. And if there's a situation that arises, perhaps not being being taken out of the promotion pool because the manager's not happy with working at home, that type of situation, that would be an act of discrimination. Associative discrimination is how the law would term that. So there is some protection for carers as well, who are caring for those with a disability. So something just to have awareness of also. So that's some legal claims. Something what we've been talking about here really is just about creating an awareness of these things. So people want to get themselves safe, and obviously you do have to take some action, then just do it positively, just with your legal rights. Running through all the ACAS. Use that positively in the first instance if that's something that happens. If in doubt, or if it's something that can't be resolved with the employer, you can of course take advice, particularly when the complexities of discrimination law and the short time limits. Always best to do that. So that's really what the aim is this afternoon. Wanted to do as well is just direct to some resources that might be useful in the future. So I've mentioned ACAS a number of times. This is the link to their guidance to work and issues. Also have webinars on there as well. So if training is a better way to get this information, then on there again there's a variety of topics and you can watch them at any time. The Health and Safety Executive, they've also provided some guidance on protecting vulnerable workers and get back to work. So again, that can be a good source. Or indeed, if we'll go to questions in a wee moment, but if anyone has any questions later, or looking at this later, then Baldwins can get in touch with myself at the email address on there. So these are just a few extra sources of information. So, questions? Anything
Thanks for that, Ross. Apologies for any of the sound issues there. I do have a question that's come from Stephanie. What should employers do if employees do not want to be in the office with people who are not vaccinated? E.g., can people who employ personal assistants insist that they are vaccinated?
I lost you a wee bit there, Susan, but yeah, there's a question about vaccination. Yeah, so at the moment, the employers aren't, other than the care sector south of the border, employers can't force someone to get the vaccination. I think that's the general position there. They can encourage people to do that if there's a particular risk and some very particular reason, then it probably be worth having that conversation. But at the moment, it's can't be forced to do that.
Okay, thank you. Is there any questions? Does anybody want to raise their hand and ask any questions at this point? Oh, we'll go to you, Stephanie.
Sorry, I want to ask a supplementary one, Ross. I've really enjoyed your session. Thank you very much, notwithstanding the sound issues. But I understand that, obviously, as we're an employer, I completely understand that vaccinations are voluntary and people can't insist. But we have had a number of discussions from people that do employ people that come into their home. And can you insist that if it's a new post, so it's not an existing employer, can you insist on vaccinations being mandatory to that job? Is there something about new people?
It would still apply the same. The same rule would still apply. So you couldn't necessarily force it. You could ask for it, I suppose. The employer would have to be. I think where there's a particular risk, say if they're caring for someone who's a medical condition and it's vulnerable, then it's still.
Cerebral palsy has been highlighted as being a condition that potentially could lead to greater risk.
Yeah, absolutely. So clearly everybody wants to take precautions. Yeah. I think the important point to be aware of is obviously not to be forced or be seen to be forcing people. But yeah, it's not to discriminate against people, not to try and force views on anyone else. So yes, there's a fine line there for employers to have to balance. This is one of the complexities that comes out of the rules and the way that's the working life is now being shaped. So yeah, it's certainly something to be wary of. It's perhaps something to take advice on if there's specific circumstances that come up in relation to that. But yeah, definitely one to be careful of.
Do you think, sorry, I'm hogging the questions, but I've got another one. Do you think that the hybrid working and the opportunities of doing things online has really helped the opportunities for disabled people to access work? Because it's demonstrated to employers that reasonable adjustments that you were talking about actually are far easier to implement than perhaps they might have thought of pre the pandemic?
Yeah, I would like to think so. I'd certainly like to think so. I think it's just made everything much more accessible. You know, people can log into Zoom calls and all the rest of it from from anywhere. I think what's been good about it is that people have adapted to it so quickly. Remember when I heard the term Zoom, just as we're going into lockdown, there's a teaching at university and they mentioned, oh, we might have to move to Zoom. I thought, what's Zoom? And here we are a year and a half later and we're all over it. So yeah, people have got onto it really quickly. The courts have as well. Employment tribunals are fixing cases online. I've been doing that for a while. We've probably done about 4 or 5 since we've all been working from home, and they all go well. I've yet to come across any major issues with that. So yeah, hopefully as people are adapting to this, then employers will get wise to that as well and see the benefit of people can use the benefit of their skills and experience and can do it from home as well.
Thanks, Stephanie. Does anybody else have a question at the moment? If you want to raise your hand on the reactions button.
Hi, I've got a question.
On you go, Anna.
Hi, Ross. I was just wondering, I suppose it was just kind of slightly sort of similar to what Stephanie was asking about, but I'm just kind of conscious thinking about, Stephanie was speaking about people with cerebral palsy, as adults who might have carers coming into their home. I don't know if there's any, what the position is. I'd be curious to find out from an education perspective and from, local authorities and when they have, vulnerable children potentially within a school setting and obviously in close contact with support for learning assistance or so on. What, is there anything that would make vaccination or a mandatory, or is it, from a employer perspective?
Yeah. So not mandatory at the moment. See, all the guidance is to ask employers to encourage people to do that, but not to insist upon it. And it probably comes down to the question of the employer managing it. How best can we manage this situation so we're not putting people at risk? So there's competing interests there. So yeah, employers might have to make difficult decisions as to how that's achieved. It probably comes down to the specifics of each circumstance will probably differ. So yeah, it's certainly something to be wary of. An employer's facing that situation, yeah, should definitely be taking advice on that, so someone can look at the detail and keep them right. So they don't want to be putting people at risk as well.
I'm just going to jump in here. We're just about to be kicked out, so I just want to say thank you very much. Just before we head out, we'll be going back into the main room for the closing remarks. Thank you.
Thank you very much.